everybody to our Fair Use Week event. Does fair use really work? I'm Kevin Smith. I'm the Director of Copyright and Scholarly Communications at the Duke University Libraries. And I know that there are some people whose names I recognize amongst the attendees. So anybody who knows me probably knows what my answer to the question is. Yes, I believe that fair use really works. But another way to ask the question is this: is fair use practical, or is it so theoretical and subjective that ordinary non-lawyers simply cannot employ it? Again, I think we can, we do, and we must continue to employ fair use. And what I hope to do this afternoon is to give you mostly some ways to think about fair use and also some ways to respond to those that it can't work. I hope you have opened the chat window and that if you have any questions, you'll type them in there. I'm not always as good as I'd like to be about leaving space at the end, but I'll do my best to address your questions either as we go along or at the end of the webinar. I also have to say I have a head cold. I apologize for any sniffling that you hear, and I will try very hard to mute the microphone if I think I'm going to sneeze or anything like that. So with that out of the way, and as soon as I find the way to advance the slides, we'll begin. So Lawrence Lessig famously said that fair use meant the right to hire a lawyer. I think that he regrets the way that has been taken over the years, but I think it's worth asking, is that really all that fair use means? And on this slide, I've listed some of the things that you hear from people who reinforce the idea that fair use is nothing more than the right to hire a lawyer. For example, fair use is only certain after you've been sued. Fair use is just an affirmative defense, which is an instance of the first remark. Or fair use is just too hard to decide and the stakes are too high. It's too risky. So first of all, it's true that you're only certain that something was fair use after a court has decided that it was. And yet we rely on fair use all the time without certainty. And Congress has deliberately given us safety valves that reduce the risk of doing so. And I'm going to talk to you about those as we go on. About fair use being an affirmative defense, and I'll say more about this in a bit, but that's true in the sense that in a lawsuit where you've been charged with infringement, you would raise fair use as an affirmative defense. An affirmative defense means basically saying, I admit everything that the plaintiff says, but I have a very good reason for it. And whatever that reason is the affirmative defense. And the fact is, many, many positive rights would function as affirmative defenses. And my favorite example is in a free speech case. Somebody who was arrested for, well, there's a famous case out of California for a man who was arrested because of an anti-war slogan, an obscene anti-war slogan that he had on his jacket. He was arrested for disturbing the peace. His defense was that it was free speech, and he was right, and he won the case at the Supreme Court level. But of course, he raised his right to free speech as an affirmative defense to the charge of disorderly conduct. So the fact that you would raise it as an affirmative defense does not mean that fair use is not a positive right. And as for it being too uncertain to decide, fair use is a matter of judgment. Judgment is something that we develop over time and with practice, and we exercise judgment all the time. So let me give you a parallel situation, something that we do in libraries all the time, hiring staff. Hiring staff is always a risk. It requires the exercise of judgment. We decide who is going to be the best fit for our organization, who is going to be the person that we can manage, that will get the job done in the most efficient way. Sometimes we get it wrong. And very often, we have to help the person that we have hired. We have to encounter obstacles with them and help them get past them. All of that requires judgment. But the fact that it requires judgment doesn't mean that we stop hiring employees or in relating to them. We simply learn to develop our judgment as supervisors. Likewise, we need to work on developing our judgment as fair use users. Fair users. I love this analogy. My colleague Will Cross from NC State uses it all the time, and he learned it from the legendary Lolly Gassaway when he was at law school at the University of North Carolina. Fair use is like soup. When you cook, you combine a bunch of ingredients and you taste the soup until it tastes right. And that's simply a skill that we learn from practice. Over time, when we've made the same soup or the same dish over and over again, we begin to understand what relationship amongst the ingredients will result in the perfect taste. And we keep experimenting, we keep tasting, we develop our judgment through practice. And that's the thing that I love about this soup analogy. Fair use is like soup because we develop a taste for fair use by practicing it. So why do we have fair use in the first place? Well, because technology keeps moving. We've gone in a very short period of time from that huge room-sized computer to even more powerful devices that we carry in our hands. The law simply cannot keep up with the development of new technology. What fair use does is it provides the flexibility to adapt to new technology without having to pass a new exception in the law every time. Sometimes Congress has tried to keep up with technology by passing special provisions in the law. I often cite the example of the special provision in the law for digital audio tape, what was called DAT tape. The problem is that DAT tape was replaced at the time by the CD-ROM in almost no time. The content producers who were afraid that DAT tape would ruin the business of radio, for example, because it would allow much better quality recordings than the cassette tapes that I made when I was a kid, were mistaken, of course. The technology changed and the provision in the law turned out to be unnecessary and pretty much useless. Fair use gives us a flexibility that specific exceptions that are tied to particular technologies or particular uses, can't give us. Fair use can adapt to the new technology. It can adapt to the use that Congress never saw coming. For that reason, fair use is the cornerstone of innovative companies. YouTube, Flickr, Google are all companies that depend on fair use. A couple of years ago, I think it was David Cameron at the time, the Prime Minister of Great Britain, said that Google could not have been founded in the United Kingdom because of the lack of fair use. And he called for a review of the copyright limitations and exceptions in the British law to decide whether or not something like fair use was necessary. At least two countries have added fair use provisions to their law. Japan and Israel have both relatively recently adopted fair use provisions. Both of them have taken the language straight from the American law and put it into their own law. Now, in a way, that's kind of odd because those countries do not have the judicial tradition of case law that interprets fair use. In the United States, we're fortunate to have 150 years, I think, 160 years of history of fair use in our courts. Fair use was first introduced into our law by a judge, Justice Story, in, I think it was 1841, something like that, in order to mitigate the harshest effects of copyright and to support uses of copyright material that the judge believed were socially appropriate. Our test for fair use actually hasn't changed that much since 1840, and we have a long history of interpretation that helps us develop that judgment, that helps us figure out what fair use should taste like. But these countries, even though they didn't have that kind of judicial tradition, perceived the value to economic innovation and to education that fair use provides. Interestingly, while both of these countries, Japan and Israel, adopted fair use provisions into their law, the United Kingdom ultimately decided not to. At least in this round of reforms, they recommended a group of specific exceptions, less flexible but more certain than fair use. And that was the way they decided to protect economic innovation. The ideal, of course, is a balance between these specific exceptions and something flexible like fair use. At least I believe that's the ideal. There may be things that are either so common or so contested that we ought to write specific exceptions about them. But I think there will always be need for flexibility in order to recognize new technologies and new uses that have such social value that we want to let them take place, even if they don't fit into any of the specific exceptions. So I think that fair use is very important for that reason. The question is, have we bought flexibility at too high a price? Have we made fair use so difficult, or is fair use so difficult that that flexibility, well, ultimately that flexibility would fail because people wouldn't try to use fair use? And the four factors sometimes seem difficult to people. They tend to be phrased in legalese: amount and substantiality of the portion used, the effect of the use on the market for or value of the original. Those things sound pretty theoretical and difficult to apply. But I think it's important to understand that these factors are signposts. They point us to the specific facts we should look at. As I often say in the soup analogy, they tell us what the ingredients of the fair use soup are going to be. They tell us what to look for. We don't have to worry about the legalese. We have to look at what it is we want to do. Is it the kind of thing that is so socially valuable it should be permitted? Is it the kind of thing that Congress and the courts have told us over and over again is what fair use should accomplish? How much are we using? Is it a teaspoon or a tablespoon? Those are pretty easy judgments, and the factors are simply pointers to get us to the facts that are important in our particular circumstances. That is, the factors help us build the ingredient list for our fair use soup. But as with cooking, we develop instincts. Once we have practice at selecting the important facts and combining them with our good judgment, fair use gets easier. Over time, you simply develop the instinct for what the soup should taste like. Whoops, sorry. I have a mouse that double clicks a lot of the time. And the courts are helping. And I think this is a really important message. The courts are helping us figure out what the fair use soup should taste like. In a lot of court cases over the past 30 years or so, courts have put a lot of emphasis on transformative fair use. And this issue of transformation, which is just another signpost for looking at the same set of facts. This idea of transformation actually makes the fair use judgment quite a bit easier in many cases. Transformation asks, are you in some way creating new meaning, putting the original work to a new purpose, perhaps an unexpected purpose, making a new point, or providing new value? If you're doing that, your use may be transformative. And then you have to ask, does the incorporated material help me make that new point? Does it help me make new meaning? Does it add value to this new use? And then, have I used no more than was needed in order to make that new point, create that new meaning, add that new value? If the answer to those questions is yes, you very likely have a transformative fair use. And once a court finds that a use is transformative, it's very, very likely to find that it is ultimately fair use. It is not absolutely necessary. The Georgia State case, about which I'll say more, reminds us that even a non-transformative use can still be fair use. But transformation is a way of looking at the factors, and it's a kind of panoptic overview of the factors that really helps make the fair use decision easier. One of the nice things about transformative fair use is that when we ask ourselves these questions, especially in teaching and research situations, in the kinds of situations that we in libraries are often advising about, when we ask these questions, we're really asking questions about good scholarship. So we can engage, especially with our faculty, really well when we look at these questions. What is it you need it to do? How will it help your students, your readers, your viewers? Are you using the optimal amount? Are you using too much? Are you not using enough to make your point? Those questions are questions about good teaching. And it's often the case, I'm sorry about that. That was actually my cell phone ringing, and I had to mute my microphone long enough to turn it off. Sorry about that. It is often the case when we have these conversations with our faculty that we find creative ways to improve the taste of the fair use soup. We find, for example, in digitizing a special collection, that we can add material that will help transform it, that will help give it a new purpose, that will emphasize the pedagogical or the teaching function or the historical function of the collection rather than its original function. We can adjust the amount that we're using. Asking these questions is asking about good teaching, and as we explore what is the best way to teach, we also find ourselves improving the argument for transformative fair use. So I think courts have helped us a lot by pointing us at this idea of transformation. But I think it's really important to understand that it is just another way, a way of balancing the same four factors, the same kind of information about a particular use that we've been doing all along. It's just that the courts have put it in a framework that I think is often very, very helpful and often a better way to help us think about fair use than we have perhaps done in the past. I want to stop for just a minute and remind you that if you have questions, please type them into the chat. I'm actually pretty sure that I will be leaving you all time for a discussion, so I want to make sure that you take advantage of the chat window. Okay, so courts are helping us by pointing us to the transformation analysis, and that is making the fair use decision a little bit easier in many cases. I'm having trouble advancing my slides here. Courts are also helping us by giving us some really good decisions that support fair use for the kinds of things that are important to libraries and to research universities. and to teaching institutions as well. In the Authors Guild versus HathiTrust, we got some really good language about the importance of libraries and research. The judges were very reluctant to find against fair use in that case because they saw the social value of the things that the HathiTrust supports. Research, being able to find things more deeply in the texts of millions of books at a time. Fair use was created to support the things that universities and their libraries do. Some of the purposes that are enumerated in the fair use provision are criticism, comment, and scholarship, exactly the things that we support in our libraries. And the HathiTrust case is a really helpful reminder that that matters to our courts. They want to know that what is being supported with fair use is the kind of thing that we want to happen, the kind of thing that serves the purpose of copyright. And remember that the purpose of copyright is to provide an incentive for the creation of new knowledge. That's what fair use wants to do, and the courts have been giving us, in a number of cases recently, really powerful language about understanding fair use in that way. The Authors Guild versus HathiTrust affirmed fair use even in a setting of mass digitization. So we're sometimes told that fair use has to be a kind of one-off thing, that it can only exist where there's been a market failure. That's another phrase that you'll hear sometime. That means that those occasional places where licensing is impractical or impossible, those are the only places you can use fair use. So it's going to be rare, a one-off, an occasional thing. The HathiTrust reminded us that that's not the case, that fair use can support even huge projects like the Google Books project and the HathiTrust that grew out of it. And by the way, fair use can support entire industries. After all, the home video recording industry is supported by fair use, as we know from Sony versus Universal Pictures. So if we look at this tradition from our courts, at the way the courts tell us what fair use is, and especially if we look at what they say about the importance of higher education and academic libraries, we get a little closer to the kind of taste, if you'll pardon me for continuing to go back to that analogy, the kind of taste that we want to find in the fair use soup. Somebody is asking what fair use looks like for proprietary educational institutions. It's a really good question. The first thing to remember is that a lot of the specific exceptions that we rely on in education say that the organization must be a nonprofit educational institution. The performance exceptions for face-to-face performance and for online transmission of performances both say that the institution has to be a nonprofit educational institution. And the so-called TEACH Act for transmitted performances goes on to say it must be accredited and that the transmitted performance must take place in the context of mediated regular instruction. So those exceptions really aren't available for proprietary educational institutions. On the other hand, fair use is. Fair use is going to be narrower. You're not going to automatically get the benefit of that first fair use factor, the purpose and character of the use. You won't be able to say, hey, it's nonprofit, educational, that's almost always going to favor fair use in our four-factor analysis. You won't be able to do that. But it may well be the case that you can still construct a fair use argument. Perhaps the particular use is not generating a profit. Sometimes courts will look at that even when the person who's asserting fair use is a commercial entity. Maybe the nature of the work, the impact on the market, maybe you've transformed the work so much that you'll still have a fair use argument. That's certainly possible for a proprietary institution. I'm going to mute my microphone just for a moment, so don't worry about the dead air for a second. There, thank you, and excuse me. I promise not to make really obnoxious head cold noises right in your ears. So thank you for the question, and I hope we'll see more of them. For now, I'm going to move on with my presentation. And once again, I'm skipping too many slides. There we go. I've already given this some weight, but I just want to remind you, courts and Congress really like us. They really, really like us. In the Kirtzang versus John Wiley case, which was not about fair use, the Supreme Court went out of its way to talk about the impact of their decision on libraries and education. You may remember that the Kirtzang case was about the doctrine of first sale and whether or not the first sale doctrine that allows us to lend materials and resell them and rent them and do all those things applied even if the works were not created in the United States. And the Supreme Court decided that it did, and it was hugely important in that decision, and Justice Breyer, who wrote the opinion, cited a brief from the ALA that made this point, that a contrary decision, a decision that we could only lend or rent or resell materials that were manufactured in the United States, would wreak havoc in libraries, and it would wreak havoc with education. And that was tremendously important in that decision. So it was a reminder, even though it wasn't about fair use, that courts and Congress really like us. They like what we do. They know that we in academic libraries support education, support the development of culture, and they try to make fair use easier for us. One place they do that is with this particular provision that's cited on the slide, where librarians and employees of nonprofit educational institutions, sorry, proprietary institution, this is another one that is specific to nonprofit institutions. Librarians and other employees of nonprofit educational institutions, libraries, or archives cannot be assessed statutory damages if they've made a good faith decision that something is fair use. Now what that means, the biggest chunk of penalty if you're found guilty of copyright infringement is statutory damages. There's a provision in the law that says you can ask for your actual damages, you know, what the allegedly infringing use really cost you in lost sales or whatever it is, but that's really hard to prove. So Congress said you, the person who believes your copyright has been infringed, can also elect or can alternatively elect statutory damages. And those damages are a maximum of $150,000 per act of infringement. They're the reason that the bill for copyright infringement can be so high. They're the reason that the risk of copyright infringement is so great. But they're off the table when you're a librarian or another employee of a nonprofit educational institution who has made a good faith, fair use decision. Now realize this is assuming that your decision was wrong. If it wasn't wrong, the issue of damages wouldn't be arising anyway. But even when you're wrong, the risk is deliberately lowered by Congress, and it's lowered really, really low. What's available are actual damages and potentially attorney's fees. So you don't want to be a copyright infringer. Nobody is saying that you should. But this is a way that Congress quite deliberately took the risk out of or reduced the risk of making fair use decisions for librarians, professors, and others who work at nonprofit educational institutions. It's a very concrete way that Congress said, we like what you do and we want you to rely on fair use when it's appropriate. By the way, there are other provisions in the law that are also intended to give us this kind of confidence in making fair use decisions, or at least in using copyrighted material. They're not strictly fair use, but I thought I'd point them out to illustrate the multiple ways in which Congress tried to reduce the risk for higher education. So, for example, in Section 108, in subsection H, there is a special provision for libraries to be able to use copyrighted materials during the last 20 years of copyright protection. This was put in because of the 20-year extension, the Soni Bono Copyright Extension Act. And once again, it's saying to libraries, we believe that what you do is so important that we're going to extend copyright for 20 years, and then we're going to put this provision in the law that mitigates the effect of that extension specifically for you. Another indication that courts and the Congress like what we do. And one more. Section 412, which is pretty far down in the weeds in copyright law. But Section 412 tells us that there are no statutory damages. Remember statutory damages. There are no statutory damages available if the work that's being used was not registered before the act of alleged infringement. So where this matters to us is in our special collections. When we want to digitize collections of unpublished works, which are almost never registered. It would be very rare for the unpublished works that turn up in our special collections to be registered with the Copyright Office. That means that if we use those works in a digital special collection, for example, and a rights holder objects, once again, they can't get statutory damages. What that means is it's just not worth suing us. So the result in most of those cases is that we end up talking to the rights holder. Sometimes we can convince them that the material belongs in a historic collection and they should let us leave it up. Sometimes they insist that we take the material down. But there's almost never going to be a lawsuit there because it's not worth it to the rights holder to bring a lawsuit when statutory damages aren't available. So once again, this is a way to remind us that there's really pretty low risk in doing the core things that libraries do, even in an online environment. Congress has seen that they need to reduce our risk, and they've taken multiple paths to do that. And having said that, I notice that somebody is asking me if an employee is found guilty of infringement, who is likely responsible to pay those attorney fees and other damages? This question comes up a lot. I almost hate to answer it because it gets us into the mindset of what if I get sued, and what I'm trying to tell you is it's very, very rare. The answer, of course, is that copyright infringement is a tort. That is, it's a civil wrong. It's like negligence, defamation. It's a tort. And the rule with torts is that when there is an employee and an employer, the two are joint and severally liable. There's a lot of legalese there. What it means is that the plaintiff, if there's going to be a plaintiff, and that's very rare, the plaintiff can sue both the employee and the employer and try to recover the damages from either or both of them. So joint and several liability means that if my employer and I are sued and found guilty and say there's a $100,000 award of damages, the plaintiff can try and get that money. They can only get $100,000, but they can try and get it from both of us. So, you know, I may only be able to put up $10,000 of it, and then the university, they'd try to go after the university to put up the rest of it. I really don't want to encourage too much worrying about how lawsuits like this would work because they don't happen very often. But the general answer to the question is that both parties would be liable. And it's not usually very effective to say, let's move the liability off to somebody else. I know sometimes libraries say about electronic reserves, for example, we want to make sure that it's the faculty member who's liable. Well, it's perfectly reasonable to make sure that it's the faculty member who makes the fair use decision, because the faculty member understands the facts around the use better than anybody else is going to. So it's very reasonable to ask the faculty member to make the fair use decision. But as far as liability is concerned, the librarian and the faculty member are both employees acting within the scope of their employment for the university or college. The liability, if there is any, in the rare case where there might be liability, is going to be shared. It's going to be joint and several, as we say. And somebody's asking about 10% as an acceptable portion for fair use, and I'm going to talk about that in the next slide. So, see if I can move it along. So what about the Georgia State University lawsuit? That is Cambridge University Press versus Patton, which is what the case is officially called. What have we learned and what has happened to us in the Georgia State case? You may recall that the trial court found in favor of fair use in 70 out of 75 instances that were challenged. Each of the challenged instances were excerpts from books. It was all about excerpts from books, not journal articles. Excerpts from books that were scanned and put into either an electronic reserves or a learning management system, and which the plaintiff said was copyright infringement where no license had been purchased. In the trial court, we got a strong affirmation of fair use. 70 out of 75 were found to be fair use. And we got that really specific rule, 10% or one chapter, whichever is less. The judge basically said, this is not a transformative use. It is mere slavish reproduction. And for that reason, the portion used must be decidedly small, was the judge's language. And her definition of decidedly small was 10% or one chapter, whichever is less. Now, the Court of Appeals reversed that decision and remanded it, that is, sent it back to the lower court. One of the things they said was that the judge should not have applied that strict rule. The publishers actually wanted a different strict rule. They wanted a much smaller percentage. They were arguing that the 1,000-word maximum from the classroom copying guidelines should be the rule for fair use. The appeals court said, no, we're not going to adopt your bright line rule, and we're not going to adopt the other side's bright line rule. The amount, the decision about the amount in fair use should be flexible, and it should be appropriate to the purpose. That's what the appeals court told us. So specifically about 10%. Is it the rule for fair use? No. Is it a good idea? I think it still is. I think it is still a reasonable percentage because what the judge told us, this is a non-transformative use. It has the potential to replace the market for the original. And one of the ways we can control for that is to reduce the amount, to make sure that the portion we use is decidedly small. I think 10% is still a good rule, except that it's not a rule. I think it's a good mode of thinking. It's a good way to start building your fair use soup. But it is not the rule. It may be that there are situations where even less would have to be used, and it may be that there are situations where more could be used. It's got to be flexible, but I think the 10%, I don't even know what to say. I don't want to say guideline. I don't want to say rule. I think the 10% number is a pretty good number as a place to start your thinking. So what have we learned from the Georgia State case? We know that fair use can apply to these kind of broad library services, even when that use is not transformative. And that's really important. The Hoppe Trust told us that these transformative uses were fair use: preservation, indexing, access for people with visual disabilities. In the Georgia State case, we've been reminded that even when the use is not transformative, fair use can still apply. We know that those classroom copying guidelines and the copy shop cases are not our guides. We don't have to look to them. They're not very practical, and both the lower court and the appeals court recognize that. We know that the amount has to be flexible. We've just talked about that. We know that the availability of a license for the specific use for digital reproduction of excerpts weighs heavily in the fair use decision. So that's a case where 10% might be too much. If there's a license available and you want to use 10%, that might be too much. But if it's an even smaller percentage, then maybe that factor weighs on your side and the weight of the availability of the license is counterbalanced. Again, this is a matter of judgment. I can't give you rules. I don't want to give you rules. Many of us will change our policies and practices because of this case, but that does not mean we need to give up. If you think about it, we're actually no worse off right now after the case has been reversed and remanded. We're no worse off than we were before the lawsuit started. And in a way, we're a little better off. We've seen that fair use can work for e-reserves. The biggest obstacles to fair use decisions, those copy shop cases and the classroom guidelines, have been pretty much removed. And we've gotten some guidance on the factors. We know that nonprofit educational uses are favored even if they're not transformative. We know that the amount should be flexible based on the purpose of the use. And we know to give extra weight to the fourth factor, especially when there's a license available. The court has given us small tweaks to our fair use recipe, but they certainly have not put fair use out of court. I think I just mixed my metaphor, but that was inevitable. They have not put fair use out of court for library activities like electronic reserves. So how do we make fair use decisions? I did it again. How do we make fair use decisions? Just a reminder, think of the factors as prompts that encourage us to consider the specific facts around our proposed use. We don't try to force the use into the factors. We use the factors to analyze the use. Ask about transformation first, partly because it so much simplifies the fair use analysis, and also because it's so central to what we do, the teaching and scholarship that happens on our campuses. So ask about transformation first. And then when it's not transformative, when the particular use doesn't look to be transformative to you, then be careful. That's when it's important to think very hard about the amount, to give extra thought to the market, to ask yourself, is this use just about avoiding a purchase? And that, by the way, is where, as I think I've already said, that's where the amount really matters. You're not going to be able to use a whole lot of something if your sole purpose, unfortunately, is to save the students money. But if, on the other hand, the faculty member is saying, it's only a small portion, I want to use it to make a very specific point, I would never ask the students to buy this book in order to make that point, then your fair use argument may still be perfectly valid in the context of a non-transformative use. I said at the beginning that fair use is a right. And I explained to you how rights sometimes function as affirmative defenses in court, but they are still rights. They are carve-outs of things that we are allowed to do as citizens of the United States. Free speech is one of them. Fair use is one of them. And in fact, the copyright law, in a rather odd place in the library exception, Section 108. In Section 108F, Congress explicitly refers to the right of fair use. So we know this is what Congress had in mind. This is a right that sometimes serves as a defense. But rights are like muscles. If we don't use them, they atrophy. The truth is, we rely on fair use all the time. Many, many instances where we rely on fair use are so common and so uncontested, such as putting a quotation into a new academic work, that we don't notice them. But we rely on them all the time. Far from saying that fair use doesn't really work, it does work, and it depends on our continuing to exercise our right to fair use. I tell you, this mouse is going to make me crazy. So we want to develop the taste for fair use. Copyright and fair use are about incentives. And so the question we should always be asking ourselves is this new use encouraging learning? Is it supporting criticism, comment, and scholarship? Or will it simply undermine the incentive for the original creator? The bottom line is we need to ask ourselves quite honestly, is this fair to both the rights holder and the user? That's ultimately the taste we need to develop to understand fair use. Now, incentives, incentive to create, they're funny things in the academic world because the ownership of copyright actually doesn't provide the same incentive for an academic author that it does for the authors of best-selling novels or screenplays or that sort of thing. But if we compare the recent cases in academia, the Hathi Trust and the Georgia State case, to things like Napster or LimeWire, it's easy to see why the latter undermine the incentives for creation, while the former serves socially desirable ends. So if you think of those extremes and recognize that what libraries do are valuable and valued uses, you understand that fair use can, does, and must continue to work for us. Fair use works if we practice it. So I'll stop there. I see that I've left plenty of time for questions. So I think Margot is going to step in and moderate some of the questions.
Hi, everyone. I'm Margot with ACRL, and I'm going to help Kevin with the Q&A here. So feel free to type your questions in the chat. Kevin, one question that was asked by Kyle. I work at a nonprofit institution. There was a college production of a Gilbert and Sullivan work. Admission wasn't charged. The performance was taped. Can we make multiple copies of this for the students involved?
Interesting question. There's a lot going on there and a lot beyond fair use. One of the things you're going to want to look at is performance licenses. That is the licenses that most campuses have to allow student, faculty, sort of on-campus performances of musical compositions. You may very well have a performance license that permits the performance of the music. And then the question will really be the scope of that license. My experience is that most of those performance licenses allow recording of the performance, and they allow that recording to be distributed in specific ways. So really here I'd say it may be fair use. I can't tell you that for sure, depending on how many you're distributing and whether or not, anybody to whom you distribute the tape is going to put it on their website. It might be fair use, but my first instinct would be to look at the scope of the performance license. Actually, I'm going to take just a minute since there aren't a whole lot of questions yet, although please go ahead and swamp me if you'd like. I just want to remind you of the 5 questions to ask when you're looking at any use, because this question really shows the value of asking 5 questions in the specific order. The first question is there a copyright or is the work in the public domain? Obviously, if it's in the public domain, you don't need to ask any further questions. You can just go ahead with your use. If there is a copyright, you have to proceed. The second question is there a license that governs my use? And I would actually say in the Gilbert and Sullivan question that the likely existence of a license probably means that that's the avenue you should pursue. If the answer is there's not a license, then we move on. Third question, is there a specific exception in the copyright law? One of those specific, this is permitted if exceptions. Because those are certain, because they're checklists, you know that once you've checked off all the requirements, you're okay, I would look to them next. So that's third. Is there a copyright? Is there a license? Is there a specific exception? Fair use comes in as the fourth question. So it's the question you get to after you've said there is a copyright, there isn't a license, no specific exception applies. Now, let's do the fair use analysis and ask ourselves if it's fair use. And then the fifth question is, if it's not fair use, how do I get permission? So ask those questions in that order. Sometimes we have a tendency to jump to fair use, to think that fair use is everything. It's not. It fits in this five-step analysis. Okay, Margot, do we have other questions?
We do. A question from Kay. Has library licensing rather than ownership of electronic journals diminished our ability to employ fair use?
Well, it depends on what the license says. I think it certainly has in some cases. Remember that when you're looking at a library license, silence is really good. It's our friend. I'm going to have to mute my microphone for just a moment again. Sorry about that. If the license doesn't put any restrictions on fair use, then fair use is still available to you. If the license is silent about fair use, you're good. You can still rely on fair use. Sometimes a license will specifically say, these uses are permitted and no others. If that's true, then you may have licensed away your right to fair use. Perfectly possible to do that, and that license certainly does restrict your ability to rely on fair use. Some licenses say fair use or the right of fair use or something like that is not affected by this license. That language is good too. That kind of language, mere silence, both of those still leave you with room to make fair use. But if the license says these uses and no other, then you've probably restricted your right to rely on fair use. Let's see. Margot, do you have more questions for me, or shall I just pick?
I'll keep on going down the line, and I'll want to take a specific one. We have a question from Angela asking, in the Georgia State case, Judge Evans stated in her original decision that if a use is fair once, the use is always fair. Does that portion of her decision still stand?
I think that it does. The appellate court, even though it reversed her decision, specifically said that the classroom copying guidelines were not going to be the standard for fair use. And that idea that you can use it one semester as fair use, but a second semester you have to pay for, that really comes from, in my opinion, a misunderstanding of the classroom guidelines about their rule of spontaneity. So I think that Judge Evans's position that if it's fair use for one group of students one semester, it's fair use for a different group of students a year later, I think that's always been the case, and I think she just affirmed it, and nothing in the appellate reversal of her opinion makes me question that. I think the subsequent semester rule was never a good rule, but I want to emphasize this too. My experience is that schools that employed that subsequent semester rule also would allow very large percentages of a work as fair use that first time. I think the judge was saying, we don't need a subsequent semester rule, but we need to make sure the percentage is decidedly small. So always think of those two things together. Make a good fair use decision, which includes, in the context of electronic reserves, a decidedly small excerpt. And then once you've made that good, responsible, fair use decision, yes, I think you can stick with it.
Thanks, Kevin. Another question, this one from Hillary. An attorney who used to work at our institution was fond of saying that fair use decisions were not relevant to us because they were decided in a different circuit, that a court in our circuit would not consider them as precedent. Is this true?
Yes and no. The way precedents work in the United States, a decision in a different circuit by the circuit court is not binding precedent in the other circuits. So we just saw a case a few months ago in the Seventh Circuit in Chicago where the judge specifically said that he didn't like the decision in the Second Circuit in the Bill Graham versus Dorling Kindersley case. He just didn't like it. He didn't like the way it was reasoned, so he wasn't going to rely on it, even though it looked like the perfect analogy to the decision he was being asked to make. He still found for fair use. He just found it a different way. But the point is, he wasn't obligated to follow that Second Circuit decision in the Seventh Circuit, excuse me. But although they're not binding, they are almost always considered persuasive precedent. In other words, you can't just ignore them. And the judge in the Seventh Circuit didn't ignore the Second Circuit case. He explained why he didn't like its reasoning and said, I'm going to reason differently. So those cases teach us how judges think, and they inform the way the judge will be standing in front of, God forbid we're ever standing in front of a judge, is going to think. But if it's a different circuit, it's not binding. I live in the Fourth Circuit. Decisions from the Second, the Ninth, the 11th Circuit are not binding in my jurisdiction. That means courts don't have to follow them, but they certainly will take them into account and look at their reasoning and decide if they apply. Of course, decisions in the Supreme Court, things like Campbell versus Acuff Rose, which established the transformative fair use analysis, or the Kirtzong decision about first sale, those are binding on the whole country.
So we probably have time for maybe one or two more questions. Here's a question from Chris. Can you think of any examples where a complete work would be considered fair use, for instance, a photograph?
Yes, I can. We just saw the case of Carew versus Prince, or Prince versus Carew, where photographs sometimes were photographs that were taken by Patrick Carew were used in appropriation art by Richard Prince, and the court found that it was fair use. Sometimes he made collages, that is, he took bits of different photographs, but in a number of cases he used the entire photograph and superimposed something on top of it or added elements to it, and because it was so radically transformative, the court said that even using the entire work in that case was fair use. Another example I can think of is, I would suggest that a student who's writing a dissertation in art history and wants to use a single image of a living artist, in order to make a specific point to support an argument, she's going to talk about elements that are only can be illustrated by actually seeing that image. I would suggest that that's fair use. It is criticism and comment. It is transformative in the sense that the work is being changed into an element of a new argument. And by the way, that's exactly what the Bill Graham archive case that I just mentioned decided about the entire work of these Grateful Dead posters that were incorporated into a timeline of the history of the dead. They were shrunk, so they couldn't really damage the market. I think that would probably also be the case for the image of the artwork that's in a dissertation. But yes, I think those are all three examples where a fair use could use the entirety of an image.
So I'm seeing it's the top of the hour. Kevin, I don't know if there are any final questions you wanted to try to address or parting comments.
No, I appreciate the attention and the questions. I'm sorry I couldn't get to all of them, but I've enjoyed the opportunity to share my Fair Use with you, Fair Use Week with you. and I apologize for the interruptions to both my speech and apparently my thought processes caused by this head cold.
Well, thank you very much, Kevin. I just wanted to remind the participants that this session is being recorded, and we'll email out and make available on the website the recording in the next couple of days. Thanks, everyone, for joining us.
Great, thank you.